Okay, I think we'll go ahead and get started with Steve's introduction, although I think most of you know Steve does not need much of an introduction. But Steve Lowry, of course, is a partner at Harris Lowry Manton. They have offices in Atlanta and Savannah. And we've seen a steady stream of really impressive settlements and verdicts coming in from this law firm in the 12 years we've been in business. Lots of 7- and 8-figure cases, including products liability, med mal cases, various types of premises liability cases, and general personal injury type matters. Some of the things that you can see on their website, and I'll put their website in the Q&A. They have had, everybody knows, I think, about this $47 million verdict in Sasser versus Ford Motor Company. That was a huge verdict they had. They also had a $43.5 million nursing home verdict, a $40 million verdict in Decatur County, Georgia, which is traditionally thought to be very conservative, but they've shown that they can try cases in some of these outlying counties that are, while they're traditionally conservative, they're showing that these skills don't really, they're not really reliant on a traditionally liberal type county. You'll see these cases again in the case metrics database. So those of you that are subscribers can use those in conjunction with your negotiations. We understand a lot of our defense subscribers also will use that data to work with the insurance companies they represent in an effort to make sure that they're properly setting reserves and giving them adequate settlement authority on cases that perhaps they don't want to try, which we understand. I think what we're going to do now is hand it off to Steve and let him get started, since we have a lot of people that have already joined us. A couple of quick things before I do that. If you have questions, please put those in the Q&A box at the bottom right-hand area of your screen. If you have technology issues or questions, please log those in the chat, and we do have our tech expert standing by to help you with those. Okay, so without further delay, I'm going to hand it off to Steve Lowry. Steve, thank you very much.
All right, well, thank you so much, Kim. I really appreciate it. Let me just first say thank you to Case Metrics for the great work that they do. We've been working with Case Metrics for a long time now, and we don't go to any settlement conferences or mediations without first checking, for similar cases around the state and around the Southeast on Case Metrics. So it's a very valuable service, and I just want to say thank you to Kim and Alan, and thank you for having me speak here. I'm going to speak on one of my favorite subjects when it comes to trial. I'm going to try and share my screen real quick. Hopefully everybody can see that. And so let's see here. There we go. Okay, so what I'm speaking about is storytelling through demonstrative exhibits, and I'll just say that demonstrative exhibits are one of my favorite parts of getting prepared for trial. Taking the time to really think about what your case is about, how you're going to present it to the jury, and then how you can present that in a way through an illustration, through a model, or through some way that you can creatively and effectively theme your case and the issues that you have to the jury so that they understand them. And the main reason why you want to do demonstrative exhibits is because most people learn visually. Some learn by touching, some learn by hearing, but I mean, I think of most people, the vast majority are visual. So it helps not only for the jury to have a good demonstrative, it helps the lawyers too. It helps explain complex issues. It helps tie messages together. It helps theme your case and helps just engage both the judge and the jury. So I'm going to talk about a number of those things, and I'll just sort of some of the areas that I think that demonstrative exhibits help with, and what I'll be covering here is that it helps with theming, it helps with engaging the judge and the jury, simplifying issues, laying out the story. One of the things I'll talk about here, and I understand that we have both plaintiff and defense lawyers on, and so while I do primary or 100% plaintiff's work, hopefully some of this will be helpful for some of my friends on the defense bar. But, you know, when we put a case together, generally we're going to be looking at it from, or we want the jury to be looking at it from the defendant's perspective and what they either did or didn't do in the case. And so one of the things that we like to do when we're putting together a trial or putting together, you know, how we're going to try a case is we try to storyboard the case. And this is just a very simple demonstrative that I had made for this that my daughter put together for me in about 10 minutes. But as you can see on there, you know, I'm talking to the client. That's me with the bald head and the blue tie and black shirt. I'm thinking about the case. I'm getting frustrated. And I'm getting not knowing how to put it together. And then I have the great idea to come up with a great demonstrative that storyboards it. And you can see at the very end of the storyboard that the jury is standing up and clapping for me because I've done such a fantastic job. And that's really what you want to do through demonstrative. So the first thing that I'll talk about is just theming the case and really driving home what you want to tell the jury and why they should find for your client. And some of the things that we, you know, like to focus on, and again, this is probably geared more towards plaintiff lawyers, you know, but I think the concepts are the same for the other side. But as you can see on the left there, you know, you've got 61% of your jurors, so 7 out of 10, approximately 6 out of 10, are going to learn by visual cues. About 2 of your jurors are going to learn auditory, and about 3 of your jurors are going to learn from kinesthetic or touching and feeling. And so you want to have a demonstrative that will help you theme this case that they can follow and they can understand. So a couple of things that I like to use demonstratives for and help tell the story of the case is one is it helps you organize your evidence and helps it put together in the time and order of the story that you want to tell. One of the things that if people have heard me talk before, talk about is this concept of primacy and recency, that the thing that you hear first and most often is what people tend to remember. And so when you're putting together the story of your case, generally, every case is different, but generally you want to tell the story from the defendant's perspective and what the defendant and their conduct and what either they did or didn't do that caused the injury to your client. So, you know, one of the, I think, examples that I've heard a lot of people talk about when they talk about primacy and recency is you might have an example of where somebody is at work, decides to leave work early, decides to take a different route home. And while they're driving home, a driver runs a stop sign and impacts them and injures that person. And so if you generally ask people after telling a story like that, what could they have done differently? They'll say, well, they should have left work on time or, you know, at their regular time or taken the same route home and none of this would have happened. And that's part of the problem of telling a story from the plaintiff's perspective is that now the jury is looking at what the plaintiff could have done differently instead of what the defendant could have done differently. And so the opposite side of that example would be that, you know, the defendant decide to, you know, stop by the bar on the way home, was distracted because he had had a fight with his wife or a significant other, maybe had a couple of drinks, wasn't paying attention, and then ran a stop sign and hit the plaintiff. So in that telling of the story, now you've placed the focus on the defendant and what they could have done differently. Obviously, you know, not had anything to drink, focused on the road, not run a stop sign. But that's just a very basic, simple example of how you want to tell your story in this case, in most instances. And of course, you know, from our perspective, if you can show that there were rules or that there were like rules of the road or policies and procedures that they failed to follow, that they violated, that led to this injury, that's always helpful for your case. So one of the great things about a good demonstrative exhibit is that it helps engage the judge and the jury. And as Kim said at the beginning, that we do a lot of product liability cases. And product liability cases can be very complex. They can obviously be expensive, and you've generally got a opposition who's going to fight very hard. But they can also involve a lot of complex issues that your average juror or even average judge may not understand unless they've got experience in it. So we use a variety of demonstrative exhibits that help us in presenting our product liability cases. And I'm going to talk about some of those. And you know, when it comes to demonstratives, a demonstrative can be anything from a very simple demonstrative. One demonstrative that I think I saw Lloyd Bell use was where a tumor was blocking a windpipe, and he basically just used a roll from a paper towel roll, put a ball inside of another tube, and showed how that compresses on the windpipe. Very, very simple, very effective. What I'm showing you here is kind of the opposite, and this is a much more complex demonstrative. But in this case, this was a case involving what we would call a false park case, where a person driving thinks that they've put the vehicle into park, but they've actually left it in this sort of no man's land between park and reverse. And I'll show you a video later that we used at the trial of this case. But when they left it between park and reverse, then hydraulic fuel begins to fill up in the transmission, and the vehicle will shift itself into reverse. In this case, we had a young lady that was driving her vehicle, had stopped, put the vehicle into what she thought was park, and was going to drop a FedEx envelope in the FedEx box. She gets out, her car's idling, and then as she's coming back to the car, she sees that it's rolling backwards. She goes to try and stop it, and the door knocks her over, pins her legs over her head, and she suffered a severe spinal injury and was a paraplegic. So this was one way. There's a number of demonstratives that we used in this case, but this was one way we were able to show the jury how a transmission works, how it gets hung up in between park and reverse, and then what you could do about that. This was something our expert helped us put together, where you see that little door, the clear plastic door that's on the left. What we had devised in this case was that if somebody left their vehicle in anything other than park, so it's not in park, even if it's between park and reverse or any other gear, if you open the door, and we had it set up to do this, an alarm would go off to show, you know, what kind of fix the manufacturer could have done in that case. And then we had a number of transmissions. In this case, this was the actual transmission from the vehicle at issue, or I mean, not the exact same one, but pulled from the same model. And then we had a bunch of other models of transmissions from the same manufacturer. And the point of that is that we were able to show that over time, they had known they had a problem with these getting hung up between park and reverse. And we were able to show that they actually, after they manufactured this vehicle, came out with a different vehicle that wouldn't get hung up between park and reverse because they had made some design changes. And if you, on the left side picture here, you can see what's called the rooster comb, and you can see the prindle there, and you see park, you see reverse, and then you see that little detent lever that goes between all of the gears. And what would happen here is that it would actually get hung up between park and reverse, and then hydraulic fluid would fill up. And one of the things that we were also able to show is that if you increase the tension on that detent lever, as they had done in later models, it wouldn't get hung up in between park and reverse. It would be one or the other, but nobody would be confused about which gear it was in. It would either be park or reverse. And so that was just another way to effectively use demonstratives in that case in order to really bring the jury into the case. And, you know, and the other thing I'll say about a good demonstrative One is they can just be fun to use. They can be fun to use in the courtroom, and it gives you something to occupy your hands with while you're talking to an expert, while you're talking to an engineer, while you're talking to the jury, and you can show how everything works or doesn't work like it's supposed to. And so, you know, and so in this case, there were a couple of examples where we actually had experts from either one side or the other, you know, take these transmissions and either get them hung up between park and reverse, or on the alternative design that we showed how it couldn't get hung up on park to reverse. And that was just very effective for the jury in that case. This is another case. In product liability cases, I find, and our firm finds, that it's helpful to use bucks, you know, to really explain the case. In this particular case, this involved a seat belt, and our client was a young man that was riding in the right front passenger seat and had been involved in a rollover. And as it rolled over, the seatbelt spooled out, causing about 18 to 20 inches of seatbelt to come off of the retractor, allowing him to move outside of the vehicle, and he was killed because of that. And so this was, you know, very effective. I will say that when you're going to use something like this in the courtroom, you need to talk to your courtroom bailiff, you need to talk with the judge and the courtroom staff about making arrangements to get that into the courtroom and have it there and be able to leave it there during trial. But it can become extremely effective for both your side, your experts, to show how things are supposed to work or not work, and same thing for the other side during cross-examination. This was actually a very simple demonstrative that we used in a case involving a young child that had been in the care of a home care health worker. This little girl was trach dependent and was G-tube fed, and we actually found a doll that had both a G-tube and a trach. And what had happened in that case is that the home healthcare worker had left the child unattended while feeding the child. You're not supposed to do that. And then the child aspirated into the trach, choked on it, and passed away. And we really wanted to be able to demonstrate to the jury, you know, how you care for a child, you know, make sure they saw where a G-tube was, where the trach goes, how it all works. So we had bought the same trach that we had in that case. So these types of things really help you explain concepts, really help the jury visualize what's going on, and really help tell the story. Tire cases. This is just another example of a demonstrative in a products case. But tire cases can be a little bit hard to understand for juries and for judges, because tires, basically the way a tire is made is that everything that's happening is trying, the physical forces, the G forces, is trying to pull that tire apart. And so when they're manufactured, the manufacturers keep that in mind, so that they make the tire in a way that it will hold together, that the rubber will adhere to the steel belts in there. And so we like to do these cutaway versions of different tires to show not only the tire that we might have at issue, but also alternative designs. But you really want to take the time to explain to the judge and to the jury, you know, how tires work, because it can be counterintuitive to understand that one, the physics of of what's happening with the tire going around in a circle, that's basically constantly putting pressure on it to pull it apart, and that oxygen can actually be toxic to rubber. And the manufacturers know this. And so when they make things like the inner liner, and if it's filled up with air, you want to make sure that no oxygen or air is seeping into the rubber, because that will cause it to degrade and come apart. So I've got a little video that we will show, especially when we're educating the judge and the jury about a tire case. And I'm just gonna let it play for you. This is in a tread separation case. So while someone's driving, and I'm gonna stop it right here just so I can show you the different parts. But so in a tread separation case, this is basically just what the parts are that make up the inside of the tire. You can see the inner liner there. That is what basically protects the tire from the air inside of the tire and is supposed to keep any oxygen or as much oxygen as possible from seeping into the rubber. You then got the body ply, then you've got your bottom steel belt and then your top steel belt. And in between that, you've got what's called the skim stock, and that coats the steel belts. And the reason why you have that is because steel and rubber are not attracted to each other. They will come apart easily unless you make what's called a skim stock. You fill it with all kinds of chemicals, and it basically forces the rubber to adhere to the steel, and that's how your tire stays together. If your tire doesn't stay together while you're driving, then you can have a catastrophic collision. But this really helps explain to everyone. Let's see if it'll show here what happens, like for instance, when you get extra pressure on the wedge that's supposed to relieve pressure and can be an area where a tire might come apart at. So as you can see, as you're driving, if this starts to happen, your tread will come off of your tire. It can cause you to lose control, cause a rollover, cause a collision. And that's what you want to be able to explain to the jury. One of the things that I love about demonstratives and helping is that it gives you, it's one of your best chances as a trial lawyer to be creative in a case. And to come up with different ways to send your message or to show the jury what you want to show them. This demonstrative right here is actually taken from a defense case, from the defense side, in a case that was tried, I think, up in South Carolina. But I thought it was very creative. I thought it was very effective. It was a railroad crossing case, and the defense wanted to show, what the train would look like to the plaintiff who was crossing, and to show that the plaintiff should have seen the train. So they basically had a full-size, fold out that was made of the train so that they could show that in court. They actually, if I remember correctly, you can see that they had lights that were on, and then they actually blew the horn in the courtroom. And so all these things to show that from the defense perspective, that the plaintiff should have seen this train coming at them, and it was effective. So, I like it when I can learn from either side, and if either side uses a good demonstrative, I like to learn from that. And this is one that the defendants used in a railroad crossing case that was very effective. Another, as Kim said, we do all kinds of cases. Some of these are simple demonstratives. What I'm going to show you here is just one way that you can talk about in an inadequate security case. This was an apartment complex case where a young girl had been murdered. And, so one of the things you want to be able to show in the apartment, that the apartment complex knew that they had a dangerous crime area, and that they basically did nothing about it. That's from the plaintiff's perspective again. And so this was just one way that we were able to show that the defendants had notice of numerous criminal incidents that had happened on their property and taken no security measures. And so we created this simple demonstrative that just showed all the complaints sort of on top of each other. And as you see, these are all violent crimes that have been happening there. And so, we use that to argue that they knew that there was a problem with violent crimes and had not done much about it, which led to the murder of this young girl. The other thing that demonstratives are very effective for, and is making your case simple. And you can see in there, one of my favorite sayings and how I try to put my case together, and most people in our firm, is keep it simple, stupid, is, boil it down to what is really important, and show that to the jury. This is another from a products case. This involved a throttle body that had gotten stuck in the closed position while our client was driving up in New Jersey. And it got stuck, and I'm going to show you here in a second, but it got stuck because there was a buildup of sludge on the back, and in cold weather especially, it would cause a stickiness, and so it got stuck in the closed position, and then when she had to jam it open, caused her vehicle to surge and roll over, and then she had a very bad brachial plexus injury. But this helps explain, we used a number of demonstratives in this case, including a model, but we really wanted to show what exactly a throttle body does and how it works. And basically, when you step on the gas pedal in your vehicle, you're not actually, they call it a gas pedal, it's actually an air pedal, because what you're really doing is allowing this butterfly valve that's on the throttle body to come open to allow air to come in, so that then the gasoline vapors can ignite. And in this case, you can see a little valve there that's called an EGR. That's the emission gas return that they had in this vehicle. And it shows that it's proven that if you have warm air, then that ignites faster than cold air and will be more efficient. So the idea here for the manufacturer was that they wanted to warm up that air as it came in so that it would ignite faster, make it a little bit more fuel efficient. The problem is that you can see the angle of the EGR valve there, and they pointed it towards the back of the butterfly valve. And that EGR valve is basically bringing emission gases right back to the back of that. So it's basically what comes out of your tailpipe is now going into the area where you'd be stepping on your accelerator. And so when exhaust comes in there, over time, it will build up sludge, basically a black sludge. And in our case, we had the throttle body that, from the vehicle, you could see the sludge build up on it. That sludge would harden and could stick, and then make it so you weren't able to press on your accelerator, so that you had to jam it open. And that's what happened here. But we really wanted to take the time to show the jury how the throttle body worked, and how this design worked, and then what was wrong with that. And I'm going to go through a couple of these a little faster. I think we eventually are going to show some sludge building up on the back here. There we go. So you can see how we tried to show that sludge builds up on the back, and over time it starts to cake in there, and then will cause it to get stuck. And the fix for this was fairly easy. The manufacturer in this case knew about this problem, had a number of complaints, had been talking with the National Highway Transportation Safety Administration about the problems, but didn't do a very good job of letting the public, including our client, know of what was happening and that the dangers that were involved here. But they did end up doing a recall. Unfortunately, in our case, the recall came several months after our client was involved in a collision. But the recall, all it did was basically move that EGR valve, instead of pointing it at the back of the throttle body, moved it so that it would point away from it, and therefore you wouldn't get a sludge buildup in the back of the throttle body. It was a simple fix, and it should have been done in our case, and wasn't, and that was a big part of our case, and the fact that they failed to warn about it. But this basically shows that when they make that fix, then now you have it so that it's not building up there. The other thing that I like to say about demonstratives is that, when you tell the jury a point, hopefully they're all listening, hopefully that they're understanding, but it's so much more effective when you can show the jury what you're talking about. And I'm sure everybody's heard about things that people talk about, like the CSI effect, that, you know, juries now have come to expect you to show things like this, expect you to have demonstratives, expect you to you know, follow the science. So you know, it's important. What I'm showing here is, this is the same case where the throttle body got stuck and then our client's vehicle rolled over. We had a number of eyewitnesses, including our client, and we had mostly good, favorable eyewitnesses for our client, but one, you can see the fella in the back there in the Chevy, was not a favorable eyewitness for our client. He claimed our client was driving in what he called a reckless manner. We really wanted to show where everybody was in relation to the vehicle and what they all saw, and why the people who were in a better position to see what exactly had happened had said that she wasn't driving in a reckless manner. And so that's really what we wanted to show here, and that's why we laid it out like this, as far as how the collision happened, was by putting the witness statements along with the vehicle and where they were and what they were doing. And then we went through from that section and showed exactly how she lost control and then ends up rolling the vehicle. It went over a guardrail. And as I said, her right arm went out of the sunroof and got pinned and basically severed all of her brachial plexus nerves in her arm, so that she had a paralyzed arm. This is back to the park to reverse case, or the false park case. This was testing that was done by our expert to show how a vehicle could get stuck between park and reverse, what would happen if that happens, and then how you have hydraulic fluid build up, and then the vehicle will shift itself into reverse. And so this is a video I'll show you just how it works. So you can see that's our expert sitting there. He's going to move the gear shift, and all this was done with cameras that were set up throughout the vehicle, miniature cameras. Again, there are some demonstrative, some things that are expensive and some that are cheap. This would be on the expensive side, but you can see it's in between park and reverse there. You can see that hydraulic fluid is flowing. You actually see the reverse lights on, and then you see the vehicle starts to slowly move into reverse. And so that was the problem that we were talking about. And this is, I'll tell you, in that particular case, it became very effective. One of the themes that we had in that case was that, you know, is to follow the scientific theory. We had a hypothesis on what happened. We tested that hypothesis and showed that our hypothesis was accurate. That in that case, it was effective to point out that the defendants in that case, while they would claim that that couldn't happen, never showed any testing to show that it couldn't happen. Never really had a good explanation for this testing here, and from our position, weren't following the scientific theory. This, as I was saying, some are more expensive, some are cheaper. This would definitely be a demonstrative that was more on the inexpensive side. But this involved a forklift driver that was stacking some lumber in a warehouse. One of the stacks had gotten kind of askew, and he went to straighten it, and two stacks above him fell on his on the roof of the forklift and crushed and killed him. And it's what we would refer to as a falling object protection system, or FOPS. It's what they refer to in the industry. Our theory in that case was very simple, that if the forklift was made to lift that amount of weight and lift it to that height, then it should withstand it in case that falls. We were able to show a number of alternative designs, but this is basically just a very simple demonstrative to show, how the lumber fell and where it impacted the roof and what happened. Again, I've kind of gone through this, but I'll just talk through some of these. A good demonstrative helps you talk through complex issues and helps you explain complex cases. If you remember the buck that I showed you with the front seat and the seatbelt, our theory in the case was that the seatbelt retractor had spooled out the belt and allowed our client to get loose. So we wanted to show both the jury and the judge in this case, how exactly a seatbelt worked, how a retractor works. And so we had our expert through these demonstratives took apart the seatbelt retractor, and then showed every part of it. When you're talking about, how a seatbelt locks into position, especially inertially, so like if it's involved in a collision or if it's in a rollover, this ball and cup system is what was being used in that vehicle and is used in a number of them. And it's a fairly simple concept. If the ball is sitting in the cup, then that retractor will stay in place. If the ball comes out of the cup, then a spring pushes the retractor up and it stops the seatbelt from spooling out. And so these are the parts of a retractor. And if you can see on the bottom left-hand part of this picture, you're looking at a retractor and you can see the seatbelt spooled up on it. But in the bottom left-hand corner there, you can see the ball that sits in the cup. You can see the little arm that would spring up if the ball comes out of the cup. And then you see the little teeth on the retractor, gets caught there. And that's how your seatbelt stops spooling out when it's involved in a collision, like a rollover. And in our case, and one of our theories in that case was that during a rollover, the ball can actually go back into the cup and it will happen for milliseconds. But in that milliseconds, when you've got such dynamic movement, in those milliseconds, you can have 16, 18, 20 inches of seatbelt that will suddenly come off the spool very fast. And so that was one of our theories on what was the problem here. This was a very effective way of explaining to the jury and to the judge exactly how a seatbelt works. Again, this is just another demonstrative of tires, showing all the different parts of the tire and making sure everybody understands that. One of the areas that I think demonstratives are very effective and pretty much useful in any case is when you're talking about injuries and the medical procedures that have been done. And so I'm just going to show you a few different types of demonstratives. This was a necrotizing fasciitis case. This mom had gone in for a C-section delivery. Her incision site had become infected. From our perspective, the doctors didn't react to that quickly enough. When you have necrotizing fasciitis, the standard of care is to go in and resect every 24 to 36 hours to hit it very aggressively. And in this case, we were able to show, and you can see sort of a timeline there on the bottom, that they had long delays between when they were going in and looking at the wound and debriding it. And because of that when they went in, instead of debriding small areas, they had to debride relatively large areas. We put this demonstrative together not only because it was an effective way to show it along the timeline, but it was also the photographs from autopsy. This mother eventually passed away. The photographs from autopsy were pretty graphic, and we were worried about turning off the jury with some of those graphic photos. So we thought it was better to put it in this demonstrative format. This would have been, not only did we have it in a slide like this, but we also had it in a board sort of fold out, like a 3-part fold out that we were able to put up in front of the jury and walk through. And we do, for most of our exhibits, when you see slides like this, it depends on them, but a lot of them will also make boards out of. One is I just sort of like to go back between using a board, using a model, using a slide, or even using a flip chart when I'm talking to the jury, and use some sort of combination of all of those. I just think it helps keep the jury interested, helps keep everybody engaged, and helps explain it. And that way you can also leave this up while you're showing other things on the screen. But another thing that we did in this case, and I don't have anything to show you on it, but we really wanted to show, as time went over, how big the areas were that they had to debride. And so we had, from the pathology, the pathologist, we had the measurements of each area section that they had to debride. And the very first debridement that they did was on, millimeters by millimeters, so a very small section, where then they delayed treatment for a couple of weeks, and then they had to go in and debride just huge sections. And we decided to show that through foam blocks. And we just had these foam blocks made where we took the first measurements from the pathologist, and we had a foam block made of that, which was very tiny. And then at each time we went up to what they had to do at the end. And so, for instance, when I was in cross-examination with the surgeon, I went through those pathology foam blocks with him, and the pathology exhibits, and said, the first time you debrided, it was this tiny little piece, and the second time it was another piece, and I'd put another foam block up there, until finally I'm putting like this giant piece of foam on top, in front of him while I'm cross-examining him. And it was just a very effective way to show the jury, how much layers of muscle, skin, and fat that he was having to take off this young lady, because there was such a delay in the treatment. And it was just a very effective way to show that to the jury. This is just how essentially a concussion injury causes brain damage. And it's just a good way to explain to the jury, the makeup of the brain and how they get injured, even if you don't see any external injuries or see much external injury. You may see some bruising, but it shows what happens, the coup contra coup type movement, and the injuries that happen to the brain in there. And this is from a case that we tried a long time ago, where it was a lap belt only case, and it showed, what kind of forces it puts on the internal organs and the spinal cord, especially of a smaller statured person like a child who might be sitting in the back seat, where they, at least in the old days, some young people may not remember that now, but at least in the old days, they had a lot of lap belt only seatbelts in the rear seats that children would be using. This is back to the case in New Jersey, where the young lady had suffered a brachial plexus injury. And one of the things that we struggled with in that case was that, she had this arm that wasn't working. It was basically paralyzed, but otherwise our client looked very healthy. She was an attractive young lady. So we were worried that the jury wasn't really going to understand everything she had gone through in order to get to the place where she was, that they were seeing, which was several years later. And so we made a series of demonstratives. With these to basically take through each step of the surgeries, to show what part of her body was involved in each part of that, to show how much of her body had been operated on and how many times had been operated on. I think we ended up having about 30 slides. I'm not going to show you 30 slides here, but this was basically just a way that we walked the jury through with the surgeon, all the different areas that have been operated on, everything that had been done. And so the red areas that you're seeing there are showing more and more parts of the body that were involved and that were operated on, to show how much she had gone through in order to get to the place where she was in front of the jury. And so it didn't take a real long time, because we basically just kind of flowed through them as we were talking to the doctor. But it was just a very effective way of showing everything that she had gone through to get to the place she was, and what was involved. So the next thing that I'm going to talk about is how you lay out the story, and the use of timelines. I'm a big proponent of timelines, and to me, it helps really, especially when you've got a large amount of evidence. It helps visualize how that evidence comes into play for the jury, and shows them, again, what the defendant knew, when the defendant knew it, and what they did about it. That's sort of the basic theme in most cases, and timelines are a big help on that. So in this case up in New Jersey we showed that the manufacturer had known about this problem since 1996, had been receiving a number of complaints about the problem, had even talked with the National Highway Transportation Safety Administration and their Office of Defects Investigation for a long time, had implemented a dealer notification program, so they knew about it, but they didn't send out the first notice to the plaintiff in this case until they had known about this for more than 5 years. And about 6 months after her injury, that had happened, about something that they had known about for 5 years. And so what we did, and what we're sort of showing there with the calendars below is, and this was based on how the evidence came out at trial, we show that they had more than 4 years of knowledge before our client's injury. And we showed that they had 59,000 complaints of throttle sticks in the closed position. And that was something that the jury, when you had mentioned 59,000, they perked up. So we showed that the manufacturer had lots of notice, had basically not done enough about it, hadn't done anything as quickly as they should have. And then our client was severely injured because of that. This is another timeline that we used in a case where a young man had been sent to a facility for rehabilitation after he had had a DUI. And there was a number of things that happened in this case. This facility wasn't approved to be a live-in facility or a residential facility, but they had presented themselves that way to a court in Florida. And then not only did they have a problem with how they were presenting themselves, but they had a large drug problem, and they actually introduced our client, who had an alcohol problem when he went in there, introduced him to heroin, and he ended up having a heroin overdose and dying while he was in their care, and he was given the heroin by one of their counselors. So this was just a way that we were showing all the incidents they had of people having drug or alcohol problems in their own facilities and had basically not done anything about it. Kim talked about the Sasser versus Ford Motor Company case. That was a seatback case where a seatback had collapsed in a frontal collision and caused our client, Kelsey Sasser, to be a paraplegic. This was just another way of showing all of the knowledge that the defendant in that case had prior to the collision. And then because it was a punitive damages case, all of the information they had afterwards, and that they still had done nothing to fix it. I'll just talk, I can see Kim's coming up, so I think I'm getting short on time, but I'll talk really quick about demonstratives on a budget. As I mentioned, not every demonstrative has to cost a lot of money. In some cases, you just don't have that kind of budget to spend on it. This was a very severe injury to our client, but it was limited insurance coverage, and we were into a bad faith situation. And this was the case that was tried down in Decatur County, and we really wanted to show all the different injuries our client had suffered. He was a police officer on duty trying to help somebody on the side of the road. He was in his vehicle when a speeding vehicle came along and just crashed into him while his lights were on. And we just wanted to very simply show all of the different injuries he had suffered from that. He was a very big guy, very strong, muscular guy who had basically been put into a wheelchair because of this and because of the amount of pain that he went through. And all we did here was just take an anatomy drawing, and then we just wrote all of his injuries along the side. So it was very cheap, very inexpensive to do. I will tell you another thing I like to do, especially in collision cases, is I'll just go out to the local toy store and buy the toy cars just so I can have them and use those in front of the jury and show how a collision happened, because it's just, it can be very effective, and it sounds simple, but it's, like I said, I mean, demonstratives can be fun too. Finally, I'm coming to the end, Kim. So finally, the one thing that it can help you do is organize your evidence. This was the case with the young, with the toddler who was G-tube fed and trach dependent. And we believe that the client had aspirated and choked and died. The defendants were trying to claim that she had some sort of underlying lung infection. So we use this to show from their own documents where in the days leading up to her death, which happened almost immediately, they were noting that her lungs were clear and that she, her respirations were even and unlabored, so showing no signs of infection. So it was a way to just take all those documents and make it very clear. The other issue we had in that case is there was a claim that the actual worker, the healthcare worker, wasn't on duty, and so wasn't part of their, wasn't under their supervision. So this happened on a Sunday. We were able to show from their own documents that on every Sunday for the same time period that our event happened, she had worked and they had paid her. And then on this one where she had worked and she didn't turn in her paperwork because, one, the child had died, two, the police and fire department had come out to the scene, and so she didn't get paid. So they were trying to say that she wasn't working at that time. So we were able to use their documents to show that she was working during that time, and had done that for the month leading up to this incident. And the final thing I'll say is that demonstratives can help you have fun. This is my law partner, Jed Manton, up in Atlanta on a late night when we're working on some case. And so we had taken a couple of our demonstratives and put them together. And then so Jed's showing the dangers of drinking and driving there in our office. So have fun with these things. This is a lawyer out in Seattle. Her name is Karen Kohler. She's a fantastic trial lawyer, but she was trying a duck boat case, whereas a tragic case where a number of people had been injured and killed in Seattle. And I saw her do her opening, and she put on the captain's hat, as you can see there. She had the duck boat whistle around her, and then she basically told the story from the perspective of the boat captain and what the boat captain, didn't do and what he was supposed to do. But, you can obviously tell that this is, one very effective way to sort of put the jury in the shoes, but you can tell also she was having fun in this case, and it resulted in a significant verdict. So so that's the end of my my presentation. And Kim, I appreciate the time, and I don't know if we've got. It looks like we may have a couple of questions.
We do have some questions. Thanks. This is good stuff, by the way. I'm really enjoying it. Paul Coates, my former boss up in North Carolina. Hi, Paul. He has a question for you. He is asking, who makes your exhibits for you?
So we've actually worked with a number of different companies, and it really depends on which exhibit that you're talking about. I can tell you that one that we work with a lot is Legal Technology Services, which is sponsored. I don't know. Whoops, I don't know what I did there. Okay, there we go. But they've helped us. We've used MetaVisuals for some of our medical stuff. I'd have to go through it. If Paul, that you've got my law firm's information on there, and feel free to email me. I'm just Steve at HLM Law Firm, and I can get you all the name of our vendors. We've worked with different ones. We do, I will say this, with Legal Technology Services, they handle all of our technology stuff at trial and have for years. So we do work with them a lot on our demonstratives. They're very helpful on that, and they sort of get how we think and what we want to do. Sorry, I hope that wasn't a great answer, but.
No, it's a great answer. And Steve, I did put a link to your website also, so you can go on there and continue more specific conversations. Also have a question from Bruce Berger. Hi, Bruce. He's asking, do you show videos of surgeries such as YouTube videos? And if so, why yes or why not?
I haven't yet in a trial, just because I think basically because the cases that I've had that have gone to trial haven't involved a situation. I think it can be extremely helpful. You know, you may or may not get an objection from the defendant, but I think it really helps them visualize exactly, you know, what the doctors, you know, like for instance, in a medical malpractice case, you might have what the doctor's seeing or didn't see or did or didn't do. So I do think they can be helpful. I think you got to, you know, be careful on how you get those into evidence, and making sure that you've got an expert saying that it's an accurate way to show it. But I will tell you, so the answer is I haven't yet, but I wouldn't be against it. I would certainly think it could be helpful.
And no, Bruce's question wasn't to me, but I did med mal for a lot of years. And one of the things I would do is I would ask my expert to provide some videos of surgeries for me. And that was for background information. So I could have a clearer understanding of what was actually happening in the OR.
Yeah.
And I would make an enormous list of questions upon watching those videos and use those in my initial interviews.
Yeah.
And my follow-up interviews with my experts, I also use those then in conjunction, just having the background information to outline depots of opposing experts or of the defendant doctor.
Yeah.
There's something about that, just bringing it into focus.
And I mean, your expert is one resource. I do think you can, if you look on YouTube, you can find almost every surgery out there. So it can be very, very helpful. And it just really helps just for background to understand, you know, what the procedure is that you're talking about.
I had one where my expert guided me. It was a unique surgery. It was a descending basilar artery aneurysm, like running right down through the middle of the brain. It's tiny and it's hard to access. And we were trying to, I defended that one when we were trying to demonstrate that as clearly as possible. And so we I had my expert actually drew a little model of that, and he brought one of the clips that you use. And his explanation was something they could really understand. He said, it's kind of like playing operation. You can't touch the sides, only the nose of the patient doesn't light up. It's much worse.
Right.
And this is the amount of space we're dealing with, and this is what we're trying to accomplish. And just with a few drawings and actually bringing that clip, then he passed the clip around. So one of my questions for you is, do you actually bring handheld exhibits and circulate them and let them actually hold, touch, and have a better visual representation of the size and shape of things that are going on?
Yeah. I mean, especially, I think that's very effective in medical malpractice cases. You know, and we've done it in product cases as well. But especially, like for instance, in the case involving the trach, you know, one thing that we wanted to show, you know, this was an infant, and you know, we wanted to show the jury really how small that trach was and how easy it would be to block if you're not watching the child like you're supposed to, from our perspective. And so, yeah, so we went out and bought, you know, the exact same trach, and yes, we would pull that out during depositions, during hearings, during trial, and show that to everybody that we can. And I, you know, the more hands-on you make a trial, the better, in my perspective. You know, for the jury, for the judge, for yourself. You know, it just really helps bring the story together, keeps people engaged, makes it more entertaining.
It does. I had a trait case a lot of years ago, and the defense was making a lot of noise about the fact that the patient was extremely obese. And
Right.
they were having trouble identifying the cricothyroid membrane because he had a very fleshy neck. And so we were able to come up with a model that was rubbery and large, and it replicated rolls of fat through there, and how you could still palpate and locate the cricothyroid membrane and use something different to get in there. And so that was not only technical, but delicate with respect to the family. And I thought that our experts were able to guide us and do that in a respectful manner. Let me see if we have any other questions in here. We're getting a lot of attaboys. Glad you're enjoying this. Thanks, Brad Souders. Glad you could enjoy us. He said, great, in all caps, presentation. Thank you, Steve.
Thank you very much. I definitely enjoyed it. And like I said, if anybody wants to reach out and ask questions, I love talking about this stuff. And demonstratives are one of my favorite parts of just figuring out, how you're going to do things in a creative manner and bring home the story. And I love seeing other lawyers who've done it and see what ideas they have.
My former boss used to tell me that it was equally as important to talk shop at a level that matched your expert,
right.
but to let them know that you knew what you were talking about, but in the same breath, virtually to circle back around and put that into words that the average juror could explain, and wrap that up with that visual that they could look at that pretty well covers the entire scope. And they're really tough to do, but one of my jobs as a paralegal was to speak to as many of the jurors as possible following. And one of the things that I was asked to do is to get feedback from them. And I would ask them, did you understand the injury? What did we do well on that? And what could we do better? And they're painfully honest with you, but that's good, because that's how you're learning for the next one, right?
And while I enjoy talking to a jury afterwards, especially when I've won, and that always feels better, but it's a little bit more painful when you've lost. But I think it is good to have somebody other than yourself talk to them, because I think they're more likely to be honest with you, or honest about what they've seen. And you want to hear as much as it might hurt. If you want to hear what you've done that doesn't work or is bad, as much as that's probably more important to hear than what you've done that's good.
We found that they're far more honest with the paralegal than they are with the lawyer. They don't want to hurt your feelings, and they'll tell a paralegal anything. And then the paralegal has that delicate job of relaying that to you, telling her boss. But that's okay. That makes you a better lawyer, makes her a better paralegal at the end of the day. Any other questions? Let me just check these one more time before we let you go. And I appreciate you guys staying on a little bit later, because these questions are good. I think we have answered everybody. Thank you so much, Steve. I love this. This took me right back to my paralegal days. Love demonstratives. We've got nothing but happy, positive comments. Thanks to everyone who joined us today. For the people on board that are subscribers, you can find these cases that Steve talked about in the database. You can also find more details about some of them on his website, which I have put in the chat. If you're not a subscriber and you want to look at one case inside the database, we can do that for you free of charge. Just reach out to us, and put that in the chat as well. You'll get a follow-up email from us. We can schedule a 10-minute online meeting with you through Zoom, just like this, but it'll allow you to see the live database. You can tell us about one case you're evaluating now. We'll actually run a search while you watch and let you view the results. To make sure that for the plaintiff's lawyers, you're not accepting an offer that's too low. And for my defense lawyers that are in here, it will help you with your next evaluation report. And I see Jeff Yashinsky saying thanks for all of this, Steve. So lots of good things still coming in. If there are no other questions, we'll let you guys run. And thanks. I love this one. Wonderful. Take care. Have a great weekend.
Thank you.
Okay. Bye-bye.
Bye-bye.